The three main stages of litigation are pretrial, trial, and post-trial. In the pretrial stage, the litigants use pleadings, discovery, and pretrial conferences to identify the facts and the legal issues involved in the dispute. The majority of cases are settled out of court at this stage. At the trial stage, the parties present their evidence to either a judge or a jury. Following the jury verdict, in the post-trial stage, the losing party may challenge the trial court's decision in an appellate court. As we learned in Chapter 1, not every problem can be taken to the courts for a solution. For example, just because your boss is irritable toward you doesn't mean that you can sue. There's no law covering grouchy bosses. However, if you think your boss treats you differently because you're a member of a minority, then you might have a valid cause of action for discrimination. We saw in Chapter 1 that 21-year-old Wanda Smith did not have grounds to sue the construction workers who whistled at her. Although she might have been humiliated, there were no grounds for a lawsuit. Only parties with a real stake in the litigation are allowed to sue. For example, only people who have been sentenced to death can challenge the death penalty. As you recall from Chapter 4, jurisdiction refers to the power of a court to hear the case. Federal and state courts have the authority to hear different types of cases. Subject matter jurisdiction refers to the type of law that's involved. Federal courts hear cases relating to federal law, or cases where the plaintiff and defendant are from different states and the amount in dispute exceeds $75,000. Cases involving litigants from different states and more than $75,000 can be heard in either federal or state court. Which court the attorney chooses is often a matter of strategy. For example, a lawyer might prefer certain federal judges, or the rules of evidence might favor the client. There are many considerations that go into the decision of where to file the case because it might affect the outcome of the judgment. Personal jurisdiction refers to the court's power to force a person to appear before it. For a state court to have personal jurisdiction over a defendant, the defendant must either be a resident of the state, consent to being sued in the state, or have some minimum contacts with the state. The law also sets a certain amount of time to file the lawsuit depending on the nature of the complaint. After the time has expired, the right to bring an action is forever lost. For example, if you feel you're being discriminated against at work, you must file a complaint within 180 days. If you're filing for negligence after an automobile accident, you usually 2 years. The statute of limitations for murder is without limits. If the nature of the lawsuit falls under the jurisdiction of an administrative agency, then the law gives the administrative agency a chance to solve the problem before it comes into the court system. Pleadings are documents filed with the court to start a lawsuit. In a civil trial, the plaintiff files a complaint. So look in this chapter of your textbook to see an example of what is a typical complaint. And a sample is also here. A summons informs the defendant that he or she is being sued and that they have an opportunity to respond to the lawsuit. The defendant replies to the complaint by filing an answer. Sometimes the parties feel that they have grounds for dismissal of the lawsuit without a trial. So instead of filing an answer, they file a motion to dismiss. There are two basic motions: Rule 12, motion to dismiss, and Rule 56, motion for summary judgment. Interrogatories are part of discovery, and they present questions to be answered under oath by the opposing side. Depositions allow lawyers to question witnesses who must answer under oath. Requests for admissions ask the opposing party to either admit or deny statements regarding specific items. Requests for documents ask a party to produce documents in their possession. And physical examinations can be requested where a party's health is an issue. The majority of cases that are filed are never tried. A settlement can occur at any time in the pretrial or discovery stages. Usually they occur on the eve of the trial. Settlement avoids the necessity of a trial. Pretrial conferences allow attorneys and the judge to meet informally prior to trial to discuss the case.